Hi, and welcome back to the Business Career College online video series. In this set of videos, we're going to examine beneficiary designations. And we're going to go through a fair bit here. This presentation is going to be 1.5 hours long. And you'll want to check to make sure that it does meet the set of continuing education credit requirements that you're seeking. As with any presentation with a little bit of a legal bent to it, we'll have our disclaimer. So this is not intended as legal advice. This is simply broad information concerning beneficiary designations. If you have a particular question, and you'll see some questions in here can get very complex, then you'll want to deal with a qualified professional to get the answer to that question. And this province covers only the 9 common law provinces and 3 territories. Quebec's beneficiary rules are not covered specifically in here. There is some general information which is helpful for those in Quebec, but there are substantial differences in the civil code, and this causes beneficiary designations to be handled substantially differently in that province, of course. So over the course of this video and the next 4 after it, this will be the set of concepts we'll explore. You can see it's quite a set of topics that we're going to be exploring here, examining, and lots of information here. So you'll want to be well prepared to absorb and think through some of the concepts that are in here. So what is a beneficiary designation? This is not a dictionary definition. This is my own definition, but designation made by, or sometimes on behalf of, although we'll see later on this is rare, the owner of property. And when we say property here, we mean property in the broadest sense. That's not restricted to real property, but rather anything that one could own, indicating who should enjoy the use of that property on the death of the current beneficial owner. One of the reasons this is so very complicated is that there are many areas of law that can have an impact on beneficiary designations. We might expect this to be purely an insurance item, but as we go through the presentation, you'll see that in fact, insurance law is only one part of this discussion. We have to deal sometimes with pension legislation, and that's obvious where there are pensions at stake. Family law can have some particular impact, and we've had notable changes in Alberta and British Columbia, as well as some sort of unusual outcomes with some case law in Ontario in recent years. Wills and estates legislation, of course, can have an impact, and we'll talk about an example fairly recently in Nova Scotia around this. And bankruptcy legislation can have an impact as well, and we'll talk about this specifically with respect to creditor protection. So we have different types of beneficiary designations available. In addition to just a straightforward beneficiary designation, we might have to make a contingent beneficiary designation from time to time, and this is often good planning, where you have the possibility that the person who's named as your primary beneficiary might not be around to receive property. Then we can use a contingent. An irrevocable beneficiary, this would be unique to life insurance contracts or any contract that's covered under insurance legislation. And here, the beneficiary designation cannot be changed, and it also restricts many other features of the policy or the contract without written consent from the beneficiary. So who can be a beneficiary? Well, really, there's not much restriction on this. We'll look in a moment at some restrictions on naming beneficiaries, but really, pretty much anybody can be a beneficiary. We talk about persons, and it's possible sometimes not just to name a person, but rather you might even name a class of persons. So there are cases where, for example, you might name your children, or you might name each of your children by name. Both have upsides and downsides. Naming your children is quite all-encompassing. If you name them by name, whatever their names happen to be, let's say Mary, Sue, and Steve, well, the consideration here is that what if you have another child in the interim? So that's where sometimes naming children can be more all-encompassing. The problem here is that this may include somebody who you didn't plan on including. There may be an illegitimate child who ends up with a claim against an estate later on. Sometimes you'll see people say children as a result of our union. And when we get into very specific considerations like that, that's where sometimes it's good to consult some legal advice. We can name corporations, and there'd be a whole bunch of stuff in here. When we talk about corporations, this might be a business. And we're not restricted to business corporations. We could also name a partnership as a beneficiary. We could name other kinds of corporations, such as societies or foundations or other not-for-profit entities. So maybe a church here, which is also typically an incorporated entity. So we have a broad range of corporate structures we can use. We can certainly name a trust as a beneficiary, and sometimes you might name an inter vivos trust, or sometimes we might actually use a beneficiary designation to create a trust, and this would create then a testamentary trust, assuming that the beneficiary designation is associated with the death of a testator. Foreign entities or Canadian entities, there's no restriction under Canadian law, with some narrow exceptions. We will look at this in a moment, where foreign entities, if there's a concern around money laundering or public policy, that could create a problem. So we've said the list is quite broad as to who can be a beneficiary. There's a fairly narrow set of people who cannot be beneficiaries, or where a beneficiary designation would not be possible. And one example is a murder-suicide. Now, there's not any provision in insurance law or otherwise that prevents this. Rather, this is a matter of public policy, where basically we have a provision, criminal code and otherwise, that prevents you from profiting from a crime you commit. And that includes not just you, but that would also include your heirs. So the problem here is that if we have a murder-suicide, and not to get morbid here, but a husband and wife, and let's say that the husband kills the wife and then kills himself, they both may have life insurance policies in place. The husband's life insurance policy would almost certainly not pay out in that case, because it would be deemed that he had committed a crime. And even if it was paid to his kids, that would still be his heirs profiting from that crime. The wife's policy probably would pay out, but the husband's probably not. If the wife had some knowledge of this happening, then probably it wouldn't pay out either. Proceeds of crime. So we basically cannot use life insurance in a money laundering fashion. So if you funded a policy with proceeds of crime, that would be an obvious one here, but this could extend to bankruptcy legislation. For example, if you had what we call a fraudulent conveyance or a fraudulent settlement, which is where you move funds without dealing properly through a bankruptcy court or a bankruptcy trustee. And terrorist organizations. We actually just had an example of this, a pretty interesting example actually, where a fellow in Nova Scotia, not through a life insurance policy, but through his will, attempted to use the will to leave a fair bit of money, more than $1 million, to a U.S. organization called the National Alliance. This is a white supremacist organization that is deemed as a terrorist group in both the United States and Canada, and the criminal code in Canada prevents the funding of terrorist organizations. So this beneficiary designation was actually stopped at the estate courts in Nova Scotia. And I would suggest it's a good outcome. There are some in the estates, amongst the estates lawyers who say that if the case had been fought better, that maybe the National Alliance could have won, but it's a case where maybe the proper outcome and the outcome under law may not have been the same thing. I think we achieved the proper outcome there. Minors generally cannot receive the funds of a policy and or any sort of beneficiary designation. There are some oddities here. For example, a minor can own a life insurance policy starting at the age of 16, but cannot receive the benefit until reaching adulthood. And we can have problems where there's some undue influence here. Maybe we have a witness to a document who's also a beneficiary. And there was a recent case that came to the courts in Ontario where we had a lawyer who had helped to draft a will who was a very senior person within a certain charity, and that charity was named as the beneficiary on that will, and that was an argument around undue influence. So there are some things we can do to wreck a beneficiary designation, but for the most part, unless we're really trying to do something unusual, our beneficiary designations are going to hold up. Now, there are some folks who are not allowed to name a beneficiary either. So minors, as an example, cannot name beneficiaries. There are some exceptions to this. One exception would be insurance contracts at the age of 16. Another set of exceptions is that minors in some circumstances can write wills, and this varies from province to province, but for the most part, a minor starting at age 16 can write a will if it's a service will, and that would come about because that person had joined the Canadian Armed Forces, or if this person is a merchant mariner, they can write a will. The other exception here, and this varies amongst the provinces quite a bit, but if there's a particular need, so for example, if this minor is an heir to a large fortune, then it may be practical to have that minor write a will. And you'd have to apply to the courts to have that happen. We should not assume that that would be permitted. People who lack capacity generally cannot name beneficiaries, so this does include most minors, but there are other limitations here as well. The biggest limitation would be somebody who's got some sort of mental incapacity and simply cannot exercise the capacity to write a will. And one of the problems here is that there's not really any substitute measure available, as we'll see in a moment. This person is often going to be forced to die intestate, which essentially means that they've made no particular testamentary designations around any of their property. Now, powers of attorney can generally not be used to make a beneficiary designation. There was a recent case in British Columbia, a case called Easingwood, and in the Easingwood case, a couple of sons actually were able to use an alter ego trust that they were the settlers of under a power of attorney to create beneficiary designations. The key thing in the Easingwood case was that they didn't create beneficiary designations that were any different from what was already in place. What they had done here was simply to mirror some existing beneficiary designations, but through a new instrument. It's sort of an unusual twist as far as beneficiary designations go. So why does it matter? Why do we care if you're able to name a beneficiary designation or make a beneficiary designation? Well, depending on where the beneficiary designation is made, and I want to be careful here that when we use a will also includes beneficiary designations. So what we're referring to here is, for the time being, beneficiary designations made outside of a will or beneficiary designations on certain properties going to receive certain treatment. So depending on the type of property we're dealing with, you may be allowed to bypass probate based on a beneficiary designation, and we'll see this as we look at specific types of property. You may have creditor protection, and this is especially true with life insurance policies, where the death benefit and accumulated values or cash values may be protected, depending on who we've named as a beneficiary. We can often achieve confidentiality that is linked actually closely to the bypass of probate, where these two items sort of go hand in hand and allow us to have an amount that flows outside of normal estate processes. And in some cases, if you've left somebody with property, that person, if they subsequently end up getting a divorce or separation, they may be able to keep assets that were received via an inheritance outside of considerations around matrimonial property. That concludes the first part of our presentation on beneficiary designations. After we take a break here, we're going to move on and look at life insurance beneficiary designations. Hi, and welcome back to the Business Career College video series. We're going to, in this video, continue our look at beneficiary designations. You should be watching this video in the second part of our complete series on beneficiary designations. The first video provided a broad overview of what a beneficiary designation is and where it can be useful and some of the chunks of law that apply to it. So here we're going to look at beneficiary designations with specific respect to life insurance policies. We're going to touch briefly on accident and sickness contracts as well. So life insurance is where you're going to most likely run into beneficiary designations for the first time if you're active in the financial services industry, unless you have a strong background in estate planning. But most likely this is the first encounter you'll have with the concept. This is very useful. Insurance law gives us a very good idea of what constitutes a beneficiary designation, and we're going to look a little bit of insurance law on our next couple of slides. So the beneficiary designation, and we're going to look at this in great detail here, can be made directly with the insurer, and this is the way most people probably get used to this, is through the application for insurance, or we can also use a change of beneficiary form, or the second method is through the use of a valid will. And we're going to talk about the intersection of those two things and how they play off against one another quite a bit as we go through this chunk of the presentation. So I've excerpted here a portion of the Insurance Act of Ontario. This is very similar to what we see in other provinces, and I should provide the caveat again here that this is substantially different than Quebec, but other than that, this is very similar to the language we see in other provinces, the exception possibly being Saskatchewan, which has a little bit of a narrower definition of some items that we see here. And I will show you later on a particular problem that has arisen in Saskatchewan that likely would not have arisen in other provinces. So we can break this down a little bit. This is where we see the original definition of what constitutes an insurance contract. So we've got our very important term here, declaration. So a declaration simply means that it's an indication this is what we want to do, and we refer specifically to the term instrument here. And then we see later on in section 171.1, which is the definition section of this portion of the Act, that an instrument does include a will. And any emphasis or punctuation is all from the Act. I didn't add anything except what you obviously see added here in my handwriting, but the quotation marks, for example, is something that's right in the Act. Now there are some things we want to note here. So it means an instrument signed by the insured with respect to which an endorsement is made on the policy that identifies the contract. So basically this means that it refers to the policy itself. The next portion here is where I want to be very clear. It has to specifically identify the contract. So if we can't identify the contract, or we don't identify the contract, or there's some ambiguity, then this is not going to be valid. And I'll show you where we've had some problems with this later on. or sometimes we get some best intentions that don't quite work out. And we want to describe the insurance or insurance fund or a part of it, meaning you can make a partial beneficiary designation or a percentage type beneficiary designation here, in which the insured, and of course we know that it's the insured who has the authority to do this, designates or alters or revokes the designation of the insured's personal representative, or a beneficiary as one to whom or for whose benefit insurance money has been made payable. It's a nice clean definition. Makes, alters, or revokes an appointment under section 193, or a nomination referred to in section 199. Section 193 is what allows us to name a trustee to take care of the insurance money for us. And section 199 specifically refers to an absolute assignment of the policy. We'll touch a little bit later on here on absolute assignment, and I should also make note here of the exceptions that arise at section 207 to 210. It's not that these are exceptions from the description of what's a valid designation or declaration, but rather what happens here is the term declaration gets used in these 4 sections to refer to some sort of proof of death, probably a death certificate or most likely a death certificate. So we just have to have the ability to use that word declaration in 2 different manners, which is where this really essentially meaningless exception comes in. And then we see here, as mentioned already, that this does include a will. And I run into a lot of confusion around this. A lot of people with a strong background in life insurance are very surprised to find this out. But in fact, we can have either the beneficiary designation made through the insurer, or we can have it made in the will. And section 192 of the Insurance Act gives us then some description of what happens with respect to the will. So we can see subsection 1 is a little bit less important here. We're not as concerned with it. Basically what it says is, hey, if we scrap your will, if we throw out the will, then we're still going to respect the portion in here that's a beneficiary designation. So designation, an instrument purporting to be a will is not ineffective, so we get double negative language there, by reason only of the fact that the instrument is invalid as a will or the designation is invalid as a bequest under the will. So basically what we're saying here is we'll keep the designation still, even if the will is no good, or even if the designation is not considered a bequest under the will, which is the language that we use in the Insurance Act to identify a designation made in a will that's not a beneficiary designation, although somewhat confusingly, and we'll see this much later on in the presentations, that the will still makes reference to beneficiary designations when we get into wills legislation. And the most important part here is we have a designation made in a will is of no effect against a designation made later than the making of the will. Basically what this means is that the latest designation rules. So whichever one is done last is the one that would supersede. And the reason in Ontario in particular that we have this exception under the Succession Law Reform Act, we'll see some examples of this later on. Basically, this allows the courts to make a determination. The courts can say, we think that this thing is a valid beneficiary designation or not. So this is actually a very common thing in wills and estates legislation across Canada today, where we have seen a fair bit of review and update in the last, say, 7 or 8 years. And the reason for that is because a lot of it had been badly outdated, but also we see with the new changes to it that in many cases, the courts are given specific authority to change a designation or to indicate that a designation was or was not valid because of some reason that might have previously not been able to be considered. So as we've seen, where there is a beneficiary designation made in a will and one in a life insurance app, the most recent one is what's going to override. In either case, it's still absolutely a valid beneficiary designation, and it still has all the normal characteristics of a beneficiary designation. Again, a lot of life insurance agents misunderstand this and say, hey, if you make a beneficiary designation in a will, you'll lose a bunch of the normal benefits associated with that beneficiary designation. We will examine this in more detail a little bit later on. So many estate planners, I'll say lawyers writing wills here, but this would include others as well, would actually prefer to use the will today. And the reason for this is because we can create more complete trust arrangements, and we can have more certainty around some questions around family law. This would especially be a concern in Alberta today. Alberta has some particular provisions in its updated Wills and Succession Act that can cause some real problems in terms of um, amounts that have been allowed to flow on a confidential basis to especially a surviving spouse. So a lot of lawyers today will prefer to do everything in the will. They'll say, yeah, those beneficiary designations that are filed with the insurer, those are good, but we could do better. Now, I don't want to put words in anybody's mouth because I do know still some in the estate planning world who will prefer to use the life insurance policy and the life insurance application in order to create this beneficiary designation. I simply want you to recognize that there are different ways of looking at this problem. And as with many estate planning solutions, there's not going to be one answer that's always the right answer in all circumstances. So a consideration here is that even though we create all the same conditions or all the same flow as far as that beneficiary designation, the one exception here is that a beneficiary designation made in a will result in a loss of confidentiality. However, we'll still have protection from claims of creditors, and that still is not a probatable asset. I'll show you later on where doing this in a sort of questionable manner did result in this asset being probated. So the specific problem that we discussed briefly on the previous slide for Saskatchewan, we can see where it comes into play here, where the Carlisle case in Saskatchewan, what happened here was there was an attempt by the estate planner to use the will to create a beneficiary designation, but the language actually made that beneficiary designation identical in handling to the rest of the will, even to the extent that the executor was involved in the flow of those funds. And that caused the probate courts in Saskatchewan to say, hang on a second here. You've tried to do things in a manner that makes this look identical to the rest of the will. It's not a beneficiary designation anymore. Now what you've done is you've actually created a probatable estate that's going to or a probatable asset that's going to float the estate. So in this case, this was no longer treated the same way. Now, I do want to remind you that Saskatchewan's Insurance Act isn't quite as robust as other provinces' insurance acts in the section that deals specifically with the will as compared to other methods of making a beneficiary designation. So when we do have a beneficiary designation, we mentioned this briefly on the last slide, we know that we get some beneficial treatment here. We know we get our creditor protection. We know we get confidentiality. We know that we get the ability to flow directly to that person. With a life insurance beneficiary designation, we can make an irrevocable beneficiary designation. This is something you cannot do with a will. Very specifically, provisions in insurance acts will prohibit you from doing this. So this is something you absolutely cannot do with a will. If you need irrevocable beneficiary designation, then you have to do that just with a beneficiary designation filed normally with the insurer. And we also can make contingent beneficiary designations. I can do this with a will as well. This allows me to have different beneficiaries in different amounts under different circumstances. If you want to do something very creative here or have lots of different provisions in place, then you're better off to use a trust. For example, if you want to restrict kids from getting money until they purchase their first home, graduate from university, get their first job, have their first baby, you can't do that with a life insurance beneficiary designation. That's where you really have to leave the funds to the estate, allow the estate to create a trust and have that trust deal with those more complex manners of leaving funds to beneficiaries. So there are some issues that can arise here around beneficiary designations. Not everybody always does things in the intended manner. And here's a good example. And I've seen this a few times here and there in different forms, but basically I've got Jim here. He owns all of OPCO. And so we got OPCO here and we got Jim. He's the 100% shareholder. And what Jim does, he takes out life insurance here. Sorry, OPCO takes out life insurance. So we have a life insurance policy on Jim's life for a key person need, presumably. So now what we should do is we should properly have OPCO as beneficiary. And if you have OPCO and HoldCo, then you can get into some more elaborate structures. But fundamentally, we should have OPCO as beneficiary. And what has happened, though, what I've seen done a fair bit actually, is Jim is married to Nancy. And for whatever reason, Jim figures it's appropriate here to name Nancy as beneficiary. And the problem with this is that it really should create a taxable benefit for Jim. So it really should be the same as if Jim is paying his premiums himself. And basically pulling that money out of the corp and then paying the tax on that. If we don't do that and Jim dies, we can have a problem here. And I've seen at least one case where CRA attempted to actually reassess Nancy to say that's all income to you, Nancy. The death benefit, which we're accustomed to being tax-free, in this case was rendered taxable. And that's clearly not ideal. Now, if we do have Jim paying the tax on the premium dollars as that's being paid, then this should keep the death benefit tax-free. The only scenario in which this is taxable is if we weren't paying the proper amount of tax along the way. And there's no definitive handling of that. Like I said, I've just seen this in one case where CRA made that push and argued that that benefit should be taxable. So here's something I've run into a little bit less common, but still a problem that can arise. And it really comes about from a lack of understanding of what an irrevocable beneficiary designation is. In most provinces, you can enter into an irrevocable beneficiary designation without problem. In Nova Scotia, in particular, you actually have to sign a form as the insured. The insured signs a form saying that they understand what a irrevocable beneficiary designation means. Other provinces don't have that similar provision. So what happens here is this couple buys a life insurance policy and they name their daughter as beneficiary. Very admirable. However, they name her as an irrevocable beneficiary. So now Evan, next child, comes along, and the problem here is that we've named up here an irrevocable beneficiary, and of course you'll remember that that means that we cannot change that beneficiary designation without consent from Kaylee. The problem here is that Kaylee is not in any position to provide consent. She's 3 years old, and a minor child cannot provide consent here. There are provisions in the Insurance Act that allow, when somebody has become incompetent, then we can petition the courts to change a beneficiary designation on that person's behalf. But the courts in this case are going to say, no, she wasn't competent. That is, she wasn't able to make decisions when you made her the beneficiary. Things haven't changed here. There's no reason why we should allow this to happen. So the problem now is you're really stuck with this policy in its current format. And if it's a permanent life insurance policy, you might have some cash value built up here that you can't access, you can't do anything with. The best case scenario here is that nobody dies before Kaylee gets to the age of 18, and that when Kaylee gets to the age of 18, that she gets along well enough with mom and dad that she's willing to sign this change of beneficiary form and remove herself as an irrevocable beneficiary. So there are some other things that can go wrong here. One of the things to consider is that if we do have an assignment of a life insurance policy, which is going to be very common when a parent gets to a point at which they give a policy to a child. So maybe the child is in their mid-20s now and the parent feels like it's time for the child to take over ownership of their own life insurance. At this point, we have no beneficiary designation. And now if this child doesn't actively make a new beneficiary designation, then for the time being, the estate is beneficiary. We have some potential conflicts with family law legislation. So Fisher v. Stevens was a fairly involved case in Ontario in 2011 in which the courts actually allowed, in this case, Ms. Fisher to actually dip into a death benefit payable to Ms. Stevens, who was an ex of Ms. Fisher's new husband, or new common law partner. They allowed us to dip into this death benefit payable to Stevens to actually pay support to Fisher. So here, family law legislation trumped life insurance legislation. And it was probably the right outcome. Okay, but it got money into the essentially impoverished partner's hands at the expense of an ex who was named as beneficiary. And that was a valid beneficiary designation. There was no question about that. The question was, can we access the funds that were paid to that person? We have a couple of potential similar arguments here when we get into constructive trust or unjust enrichment arguments. These are scenarios where you have a death benefit paid to, and I don't want to say this the wrong way, but I'll say paid to the wrong person, where basically you've got somebody who should be the beneficiary of a life insurance policy. For example, I'm happily married, I have a spouse who depends on me financially. Most likely, she should be the beneficiary of much of the insurance that I own. If I die and I've been paying premiums for the whole time we've been married on a life insurance policy where maybe an ex-partner of mine is the beneficiary, well, my spouse would say, hang on a second here, that was our money. That money should have been used to enrich me, or I gave that money to my spouse, to Jason, as a constructive trust. That was for us. It was not for her, whoever her happens to be in this case. And then we could have some ambiguity as well. And Bossy v. Bossy was a recent case in British Columbia, in which case one brother attempted to disinherit his brother. He had bought a life insurance policy where his brother was the beneficiary. And when he named his brother as beneficiary, they were doing business together, and then at some point he had a falling out, and he writes a will, and his will says, under no circumstances does anything go to my brother. Now, you may recall when we looked at our excerpt from the Ontario Insurance Act earlier, we said it had to be a specific reference to the contract. And the argument here is, well, this wasn't a specific reference to the contract, so what ended up happening here was the spouse of the now deceased Mr. Bossy sued the brother of the now deceased Mr. Bossy to get the death benefit, saying, hey, this will said he's not supposed to get anything at all, but the courts in fact upheld that the beneficiary designation in this case overrode the will. because the will did not make reference to the life insurance policy or the life insurance contract in any way that the courts considered meaningful. So then we look at a couple of other potential problems here. We have to consider that we have this giant upside here with beneficiary designations, that if we do this right, we have creditor protection during lifetime. Okay, and that's generally a good thing. It's a valid reason to make a beneficiary designation, and these would be the relevant beneficiaries where we would get this creditor protection of cash values during lifetime. At death, there's always going to be creditor protection, but we have to make sure that we're not doing anything that would be in violation of bankruptcy law. Bankruptcy law says, hey, if you were trying to hide money, if you're actively using your life insurance policy to hide money, then we're going to overturn that. We're not going to allow that beneficiary designation to hold up. We're going to throw that out. So we'll switch gears here a moment and we'll look at accident and sickness products. And we can also have beneficiary designations here. This is a little bit tougher. So obviously, with policies like a critical illness policy or a long-term care policy, in case somebody gets sick, the benefit is paid to the policy owner, with the exception of a critical illness policy purchased as a key person policy in a business, which is rare but is possible. Sorry, that's correct. I apologize. In that case, the business has bought the policy and it would be paid to that business. So yes, that is also the same handling there. Sorry about that. So now the question is, what about return of premium at death? Is this a death benefit? And therefore, if it is a death benefit, would there be a beneficiary designation here? Well, as of today, only a few provinces have passed legislation to create a beneficiary designation on an accident and sickness policy. This is the case as of today in British Columbia, Alberta, Manitoba, and Quebec. Ontario has made indications this way, and basically this would say, yes, you can actually create a beneficiary designation. If we don't have a beneficiary designation, then we should use the will. Basically, the return of premium in that case would be an asset like any other asset and should just be handled accordingly in the will. It would be subject to probate and claims of creditors, and there would be no confidentiality and all the issues that go along with that. And of course, that would only be a concern where it's a return of premium at death. So I hope that's a good broad overview of beneficiary designations with respect to life insurance policies. Lots of issues there. And of course, we can do things in a very simple manner here. We can just have a beneficiary designation made with the life insurer and have that just go in the manner it's intended to. We can try to use the will, but we saw there's some potential complexity that arises there. I should also mention that if you're going to use the will to create a beneficiary designation, it is appropriate to file that with the insurer. Not all insurers will necessarily accept that, but if you can file it with the insurer, it can prevent some confusion when the time comes to actually pay out a claim. So we're going to break there, and in the next video in the series on beneficiary designations, we're going to look at how beneficiary designations work with respect to insurance investments, primarily segregated fund contracts. Hi, and welcome back to the Business Career College video series. In this video, we're just going to look very briefly at a couple different products where there's a beneficiary designation concerns. This will be the third in our series of videos concerning beneficiary designations. In the previous video, we looked at life insurance beneficiary designations, and we'll see there's quite a bit of overlap here. So when we look at segregated funds, for the purpose of insurance legislation and most other legislation, they're actually treated identically to life insurance. So as with a life insurance policy here, it's possible to make a beneficiary designation, which would then result in creditor protection. If you've named the proper beneficiary, creditor protection during your lifetime, if you've named a parent, spouse, child, grandchild, or any irrevocable beneficiary, and creditor protection at death if you've named any beneficiary other than your estate. And of course, there are the similar concerns that we saw with life insurance, where if you're trying to hide money, that bankruptcy courts will typically see through that. So, and then, sorry, we'll also have the ability to have this pass independent of the will. And that is actually a frequent reason why segregated funds are used. And we see this third on our list here, is that this allows beneficiary designations which can create confidentiality, which is often of concern for people who might have some money and maybe a group of heirs that they're not particularly certain are going to react the way they want if they know how much is being left to each of them. And this also would create the creditor protection we previously talked about. Bypassing probate is something to consider here, but I really like to limit this discussion around bypass of probate. This works out okay if you have similar costs, or sorry, if you have a similar cost with segregated funds as with other investments, but I always like to give this caveat. So let's say that we're in Ontario, because it really gives us the worst case scenario for probate. And Ontario hits you with a 1.5% probate or estate administration tax. And I know this isn't always representative, but let's say we have the choice here between investing in a mutual fund, and this mutual fund has, let's say, a 1.5% MER, and then we're looking at a segregated fund similar to the mutual fund but with a 2% MER. Well, the question here is that 0.5% higher MER a sufficient justification for bypassing probate? And while it's not perfect math, it roughly works out that if you're in this fund for longer than 3 years, you would have more money in the mutual fund than in the segregated fund. So if this is the only argument you're making is around an enhanced estate value because the reduction in probate fees, you really have to watch what else is happening here. There could be other reasons to use segregated funds, but this is one thing to at least be aware of when you're making this type of recommendation. Pensions are a little bit stickier with respect to beneficiary designations, and there are some reasons for this. Generally, when we're dealing with pension legislation, and I want to be very careful here, we're talking about registered pension plans. This would be a defined benefit or defined contribution plan sponsored by an employer. And yes, technically an individual pension plan is also a registered pension plan. This does not apply to group RRSPs or deferred profit sharing plans. This refers very specifically to registered pension plans. So here we have to name a beneficiary, and if you have a spouse, you generally must name that person as beneficiary. It may be possible to obtain a waiver. And then we have some other questions here when we're dealing with common law partners. Are they treated the same way as spouses? And this does vary from province to province. Now, if you don't have a spouse or common law partner, again, this varies from province to province and from pension to pension, you may be able to name another beneficiary, but that's not something that you should assume. You should know what the pension legislation says for your particular jurisdiction, and this may be limited. This may be limited to minor children. Maybe you can't name your adult children here. So we really have to be careful with pensions as to who can be a beneficiary. And this is something you would want to research on a client-by-client basis before you make any recommendation around making any changes here in order to allow the naming of a beneficiary. That concludes our short presentation on pensions and segregated fund investments. I hope that's been helpful, and I hope you enjoy your continued studies. Hi, and welcome back to the Business Career College video series. In this video, we're going to continue our continuing education series around beneficiary designations. This will be the fourth video in this series, and in this video we're going to talk about registered plans and what happens specifically in terms of beneficiary designations with respect to registered plans. So we're going to start with the RRSP and the RIF, and this will include all of their various locked-in equivalents, LIRA, LIF, and so forth. These plans allow a beneficiary designation, and it's something that sometimes people aren't fully aware of, but you can essentially create a beneficiary designation here that will react in a very similar manner to the way in which this will happen with a life insurance beneficiary designation. There is probably one major exception that we have to note, but we can see then that if you have a beneficiary named on your registered account, your registered account will bypass probate, and then there will be no tax payable by the beneficiary, by the person who receives that amount. Any tax burden that there would be borne by the estate. Really what happens here is it's paid out of your terminal return, the last tax return that's filed that coincides with the date of your death, and that would reduce the value of the estate. So there would be less funds available to flow to whoever is left, or to pass on to whoever you leave behind. And this can actually create a little bit of a funny scenario here. It is possible that you name a beneficiary who isn't going to receive anything else from your estate. That person would receive the full amount of the registered funds, whereas the estate then would have less money to distribute to all the other beneficiaries or heirs. And then we could have creditor protection possible here. Now we have to be a little bit careful with this. So yes, we do have creditor protection, but as we've seen previously, if there's any sort of fraudulent conveyance or fraudulent transfer, that is an attempt to actually defeat bankruptcy legislation, that creates an issue. Related to that, a further complexity with that is that we also have a concern with the person who actually receives the money, where if there's no other money available to pay this tax burden that I talked about up here, and this person, the beneficiary, gets all of the registered assets, the issue that arises here is that the beneficiary now will have to pay the tax. So the Income Tax Act actually allows CRA to go after the beneficiary if there's no other possible means available of recovering the taxes owing associated with the demise of this deceased person. Now, obviously, that's not going to be a concern, and nor is the previous example. These are not going to be a concern if there's a rollover available. And we'll talk about rollovers in a moment. So on the previous slide, we looked at the different scenarios where rollover is available with registered plans. We said you can, where a beneficiary designation is available, you can leave your registered plan or registered funds, your registered assets, to anybody at all when you're deceased. However, the limitation here is that if you want to get a rollover, that is, if you want to defer your taxes, then you're going to have to name one of these three groups of people as your beneficiary. And if you do this, then we will create a rollover and we'll defer taxes until this person takes the funds out. So first off, whoever you're leaving this to does not have to have any room available in an RRSP to receive a rollover. I will show you one example in a few minutes where there does have to be room available to obtain a certain kind of rollover, but with the RRSP, if we're going to just have funds rolled into an RRSP, then there's no limitation on this based on available room. Now, we have had some issues around conflicting case law here. It can happen that your will and your RRSP have different beneficiaries named. And unlike with insurance legislation, there is no clarity here. There's no place in which legislation says this is what has to happen in the event that we have a conflict. Unlike with insurance legislation, where it's very clearly spelled out, this can run into a further complication when you have the third possibility here is that you actually have a segregated fund contract, and you might have a segregated fund contract where it has a different beneficiary designation than the actual RRSP account does. So unfortunately, we don't know what happens here. This is not a new problem. We can find this problem explored in some depth in a Supreme Court of Canada case, Rangotra, in the late 1990s and 1997, but we don't have any attempts to fix that from a legislative perspective at this point. So our rollover rules do get a little bit complicated here when we have a minor child involved. And we really have some questions that we have to ask before we head down this path. So yes, passing this asset on to a minor child can result in a tax deferral, and it can generate some tax efficiency where basically now the minor child has to take this money out, which then would mean it's taxed at their income tax rate, and they would take it out in equal installments. They would have purchased an annuity. There's actually a requirement here with the last payment to be made no later than their 18th birthday. So the question here is, would you rather that this kid have the money? Is this good? Or would we rather write a check to CRA and keep what's left? Keeping in mind that this child will now own this money or this account, which means that we really can't put much restriction on how they can spend it, and we can't use a trust here to accommodate this. There's no trust arrangement that's set in law to accommodate this. So really, will this money all be blown by poor decisions? And it's not like 18-year-olds or kids, sorry, are the only ones that can make bad investment decisions or bad spending decisions. But certainly this person could easily fritter away this money. It might have been better to say, no, I don't want to roll over. We're just going to pass this to whoever we want to pass it to. We'll pay the tax, but we know that then we're going to be reasonably safe with where we're at. Now, the other thing to consider here is that this minor child must be dependent. And the actual definition of dependent is that they have some sort of dependency relationship with their parent or with whoever's passing them in the rollover, and it has to be a parent type relationship. It can't be just anybody. And their income has to be less than the basic personal amount, which is currently right around $11,000. Now, if the child is infirm, so child's infirm, now we have a little bit more available to us in terms of planning opportunities. Infirm is really, from the perspective of the Income Tax Act, another word for disabled. Now we can roll it over to the child's registered disability savings plan. However, we still have to respect the $200,000 lifetime maximum for RDSP contributions, and this will attract no grant or bond money. So now the child will have this money available to spend, and this child does not have to be a minor. Sorry, I don't know if I mentioned that. This can be done at any age. This child does not have to be a minor to receive this, or we could roll it into their RRSP. and now they simply would take it out under the normal provisions for an RRSP. They would RIF no later than age 71 and so forth, and there is no maximum here. And this is very similar to a spousal rollover into an RRSP. We can just roll that in there, no issues. Now, something else that can happen, it would be pretty common that you've actually named your partner, your common law partner or your spouse as your beneficiary, but you still might have a disabled child. So there actually is a provision where if you do name your partner, your spouse, your common law as beneficiary, after your death, then these funds can be transferred on a post-mortem basis to this disabled child to their either RDSP or RRSP as if you had originally named them as beneficiary. And here's where we at least overcome one of the problems that was addressed earlier here. If this infirmity is mental in nature, it has to be mental in nature. That is, there's an assumption around reduced capacity. Then there's actually a trust that can be established here to accommodate this rollover. But it's in this very limited circumstance where we have an infirmity that reduces the mental capacity of this infirm person. And I should mention as well that in order to receive this rollover, this child has to have income now not less than the basic personal amount. We have a little bit more latitude here. We're looking for income less than the combination of the basic amount and the disability tax credit amount, which is going to put us right in the range of about $18,000 this year. It's currently 2014, and that amount would index to inflation every single year. So continuing on to our next registered plan, we'll look at the Registered Disability Savings Plan. This one's a little bit more of a complicated beast. And the reason for this is it's not intended to leave behind any amount for anybody else. So because it's really designed to take care of a disabled person during their lifetime, we're actually not allowed to name any beneficiary here. There's no beneficiary designation permitted. So we can't choose just any beneficiary. It has to flow through the estate of the deceased person. And this can generate maybe some unintended consequences here where it wouldn't be uncommon to run into a disabled person who may lack capacity and now because this person lacks capacity, they can't write a will, and now their property would all flow subject to an intestacy, where it would flow at the discretion of provincial intestacy law rather than flowing somewhere at the direction of that disabled person. Now, I suppose because that person lacks capacity, we could argue that's not that big a deal, but this is one of these things that is complicated and sometimes hard to deal with for the survivors. And the Registered Education Savings Plan is another plan where we see that maybe it doesn't work at death quite as much as we'd like it to. It can have its own set of problems that it creates. Now, what we're looking at here is what happens on the death of the plan subscriber, which is generally the parent, whoever has the parental type relationship with the person who's intended to eventually go to school, the plan beneficiary. So if there's only one subscriber, which is a common enough thing to see, then when that person dies, it has to pass through their estate. And hopefully we have dealt with this in the will. It's pretty common though actually that people who have RESPs haven't really thought about this asset as being their own, but certainly from the perspective of estate law, this is that person's asset, and if the will doesn't address it, then we may have a partial intestacy here. So it is important that we address this in a will. Now, in a simple husband and wife first marriage situation, it's probably not that big a deal. But where you have a more complicated family setup, then that can be something to look at. Where's that thing going to go on the death of the subscriber? You can also name joint subscribers, and this essentially creates a successorship where the first person to die leaves behind these assets for the new subscriber. And now the new subscriber would own those assets instead of going through the estate. And that's a pretty easy thing to do. It's easy to name joint subscribers, and there's no concern around any tax consequences or anything like that when we do that. Now, when the RESP beneficiary dies, so now this is the probably child who we were intending to pay for their education with this plan. And if this person dies, it's really the same as winding up the plan as if that person had not gone to school. So we pay back all the grants and bonds. Any contributions go back to the plan subscriber, and any growth on the plan is paid back to the subscriber as an accumulated income payment, which means that it's either going to roll into their RRSP, or if they take it non-registered, taxed at their marginal tax rate plus an additional 20%. The last of the registered plans that we'll examine here is the tax-free savings account. And with the tax-free savings account, you can actually name any beneficiary at all. This is something that I do run into some confusion around, but anybody at all, absolutely anybody. And now that person gets that money tax-free, just like the name of the account. It's going to bypass probate, and barring any sort of bankruptcy problems here, it's also going to pass creditor protected. Now you can, and if you have a spouse or common law partner, probably should name this person as the successor owner, a successor annuitant. The terminology varies from province to province. And if you do this, now it's going to roll into the surviving spouse's tax-free savings account, even if they don't have any room to absorb it, and it doesn't use up any of their room. So all that happens now is whatever was in the deceased person's TFSA just bounces into the surviving person's TFSA with no impact on contribution room. Any unused TFSA room is lost at that point. So that wraps up our registered plans. I hope that that's helpful. We're going to look at wills and trusts and a few other more complex provisions in our next presentation, continuing the Beneficiary Designations Continuing Education course. Thank you. Hi, and welcome back to the Business Career College video series. This video covering wills, trusts, and we'll talk briefly about joint ownership as well, is the last in the Beneficiary Designations series. It's the 5th video in the series, and it will wrap up some of the concepts here and look at what are really some of the default provisions and then some other things that we can do around beneficiary designations. So most of the assets that you're going to own in your lifetime, that one would own in their lifetime, are going to flow through the will. Most things you can own, like most real estate or non-registered investments or brokerage accounts, are going to have to flow through some other method where you can't have a direct beneficiary designation on that product, but instead you use your will to create those beneficiary designations. Now, when you do this, we have several concerns here. The first is probate. Now, probate is something that a lot of financial advisors, I would suggest, scare their clients around a little bit, and it doesn't have to be that big a deal. With probate, there is a cost associated with it, and there can be a couple costs here. The provincial court system is going to assess a tax or a fee, and this varies quite a bit. A lot of people talk about Ontario's probate, for example, at 1.5%. It's 0.7% in Manitoba and Saskatchewan. It's 1.533% in Nova Scotia, Alberta, maximum $400. So we have quite a variety of probate taxes or fees across the country. The other consideration with probate is that you can have some additional costs here. Some lawyers, in order to actually administer your will, not to act as executor, just to help with the flow of assets here, are going to assess a further fee for every dollar that flows through the estate. So this can be prohibitive, but you want to understand where these costs are coming from and what you're paying for here. And really what you're paying for with probate, this is a degree of assurance that your stuff is going where it's supposed to go. This is basically the province saying, yeah, this stuff went where it should go, or the province is basically validating or confirming the will here. And without this process, you'd have an executor who's really free to do whatever they want. Taxation, for the most part, beneficiary designations don't really help us with taxation. Yes, there are some products like life insurance that have good tax characteristics at death, but we're still going to have tax on pretty much all of the stuff that we have when we die. Accumulated capital gains tax, for example, would be a concern here. Your creditors. Certainly your creditors are going to want to make sure that they get paid whatever they're owed at this time. And this is a straightforward enough process. Your executor is going to track down your creditors, make sure that they're aware of any debts that are outstanding, and give them an opportunity to have that one last crack at your stuff before you're gone. Loss of confidentiality, and this is one that maybe doesn't seem like a big deal. I don't know. I've seen some things around this lately that make me a little bit uncomfortable. This means that with your will, once you die, part of what happens when you put your will into probate, that will is a public document, which means anybody, not just anybody who's interested, but anybody, although you'd probably have to be interested to do this, could go to the court clerk, drop their roughly $12 to $20, depending on the province, and probably 25 cents a page for photocopying, and get the court clerk to give them a copy of your will. So one of the things that bothered me a little bit, we had a recent death in Canada of a fairly high-profile politician, and when this person died, there was some enterprising journalist who took it upon him or herself to actually go and get a copy of that person's will and wrote an article about this in a major national newspaper, detailing this particular person's estate and what they had done and how much they had saved up and so forth. It was really, in my mind, a little bit of an invasion of privacy, but there's no privacy owed at this point. That person is dead and there's no sort of public duty of privacy here. So it ends up that, well, I might not like what that journalist did. That's certainly something that anybody could do. And we see this a fair bit in the United States. If you're an avid reader of certain American publications, they will often go and research the will of a recently deceased person. And other processes typical to a will. This can include things like challenges in court. Unfortunately, it does happen that people decide they want to challenge a will, so we can have some various issues around that kind of thing. So we did discuss this briefly in the second presentation, the presentation around life insurance, but it has become something of a standard practice for certain estate planners to prefer to use the will to make any beneficiary designations. Now, it's not to denigrate the practice of using a normal life insurance application to create beneficiary designations. That certainly is a straightforward enough process, and it's one of those things that I would suggest the giant upside of it is its simplicity. However, if we do want to go beyond that very simple solution, then we can use our will to make a beneficiary designation. If you're going to do this, you want to be explicit. We have to know that you're referring to this life insurance policy. You want to write this out so that it's clearly a beneficiary designation, so that it's obvious what you're talking about here. And I had mentioned the Carlisle case in my discussion earlier. It's a case where there was some confusion as to whether we were talking about an executor or a life insurance beneficiary designation. Make this a clear standalone element. We don't want to create ambiguity here, and some of the problems that can arise, I talked about a case called Bossy v. Bossy earlier. It's a case where a fellow tried to use his will to revoke a beneficiary designation, but he was very unclear in doing so. Or we see people do things like use terminology like all my insurance, which is actually not as clear as it seems. For example, what is my insurance? Is that an insurance policy that I own personally? Is it an insurance policy where I own a corporation that has an interest in my life and it has some life insurance as a result? Does this affect that insurance? So anything that creates ambiguity here is problematic. That's where we want to make sure we go back up and make sure that we're completely explicit and clear in what we're trying to do here. And not all insurers will necessarily want to know this, but it is generally advisable that we inform the insurer that there's been a beneficiary designation made in the will, and this prevents any sort of ugliness at the time of death where the insurer pays out a death benefit and then we have to go back and potentially sue the original beneficiary to get that money back so the insurer can pay the money to the second person, or we could possibly have claims between the beneficiary and the person who originally thought they were the beneficiary. So we want to keep any sort of ambiguity off the table here. So there are lots of things we can do with wills. Wills can be very flexible, very robust tools. Essentially, if you can imagine a sort of outcome, then it's possible to create that with a will, as long as it's not contrary to public policy, as long as it's not criminal. We looked at some of those restrictions in the first presentation in this series. I can use my will to establish a trust. It would then be a testamentary trust, because of course my will has no effect until I'm dead, which is exactly the condition for a testamentary trust. We can create bequests, devices, and residual distributions. A bequest is basically where we say this person is supposed to get this specific piece of property. A device is the same thing, but it refers to real property. And a residual distribution, this is actually probably the most common type of distribution. This is where we say maybe my two kids each get 50%. That would be the residue of what's left after all debts are paid and so forth. And of course we would leave this to a lawyer to give us some more flowery language to make sure that this language is appropriate for the particular jurisdiction we're in. And by the way, the payment of debts here is what we refer to as an exoneration. We make sure all those debts are exonerated. We can create mutual wills here. This is sort of a complicated thing, and it's not something that I would necessarily recommend, but there are situations when it's appropriate. And what a mutual will does is it creates an obligation on your heirs. And so you say, look, I'm going to leave something to this particular person, but they then have to leave it to somebody else when they're done with it. And this is actually a somewhat common arrangement in second marriages, where you're going to leave stuff to your second spouse, but you say on your death now, I want you to leave that to my kids from my earlier marriage. That would be a mutual will, and that is a binding arrangement on that heir, on the person who inherits your property. It's common enough in Ontario to see this, second wills. This would be where we're using more than one will to create our estate. It's not something you would normally recommend. Normally, the process of writing a second will wrecks the first will that's written, but a good lawyer in Ontario can do a second will, and what's going to happen here is basically you use the first will. That's the one that's going to be probated. Oops. That's the one that's going to be probated, and that's where all of your personal and family assets would go. And then you would have your second will, and this would include assets that don't have to be probated. Most often this is used for shares in a small business. There are other things that can be flowed through that second will, Jewelry, art, and antiques sometimes get dealt with there, physical property that doesn't necessarily have to be probated. And what's going to happen here is with the second will, we won't probate it. We'll bypass that process, and we'll just use some other means to make sure that we know where this stuff is supposed to go. It has some risks with it, but it's a common enough arrangement in Ontario. We do have to watch. There are some tax changes coming in 2016 that could actually hurt the second will. A recommendation that we see more and more of today in Canada is that instead of using the will by itself, that we complement the will with a trust. And a trust, of course, is an arrangement in which I say, look, here's where my property is going to go, and here's when it's going to go there. I allow somebody else to have ownership of that property and a separate person to exercise control over that property. So I create a beneficial owner and I create a trustee. So we would have our beneficiary and our trustee, and the person who originally establishes the trust would be the settlor. So what you can do around this type of arrangement is you can have the settlor who, on an inter vivos basis, that is while alive, settles some property into the trust. So we put whatever property we want in here. Now this can have some tax consequences. We have to be aware of that. And then we're going to have two different beneficiaries. We're going to have most likely the settlor while alive, and maybe their spouse as well. But then we say, hey, when that person is gone, then we're going to name a bunch of other beneficiaries. We're going to give other people a remainder interest or make them have a residual interest in the trust. And what you've done now is you've created this document while you're alive that's basically going to take care of all of your distributions. And you can do basically the same things, even with a little bit more flexibility as far as how we decide where this stuff goes. So we can do lots of different stuff here. Now, there are some things to consider here. If you're going to try this with insurance policies, you probably run into a problem. We saw in an earlier presentation that the Insurance Act allows a beneficiary designation to be made by will or to be made by a valid designation filed with an insurer. It makes no particular reference to a trust. It's not to say that it's not possible, but there's no provision for it in the Insurance Act. And there can be some further problems with holding insurance in this trust. We get into some potential tax complications that we'll deal with elsewhere. So this is something you'll see quite a few estate planners and estates lawyers recommend, and we'll look at some of the upsides on the next slide. Trusts have some benefits then, and what are we looking at here? Well, the biggest benefits here likely are the bypass of probate. So this is where we don't have to worry about those probate processes, but we also create confidentiality. So here we're not going to know what asset was flowed where. There's no filing requirement for trusts. They have to file tax returns, but they do not have to file any sort of information that would be accessed publicly. And what we're going to do here is maybe be able to create some stricter, better defined conditions for the distribution of property rather than waiting until our will comes into effect and we're not going to be there to see it. With this, you could write this trust during your lifetime and really know exactly what that's going to look like. It's very difficult, not impossible, but very difficult to challenge a trust arrangement. We just had a case come to the BC courts, actually 3 cases, called Easingwood. And Easingwood gives us a good example of a trust where the trust was used basically to replace a will, and with success, despite a couple different challenges from one of the intended heirs. So this kind of thing, this Easingwood case, gives us some good indication that the concept of using a trust rather than using a will can work out. Now, joint ownership sometimes gets brought into the estate planning discussion. I'm very wary about this. It is worth mentioning, but you'll find that joint ownership as an estate planning tool has largely been defeated in the case re Pecor estate. And this is a case where it's not exactly clear, but it looks like a parent intended to use a joint ownership so that one of their children could manage their assets. The child perceived an attempt to enforce rights as if the parent had used joint ownership to create an estate objective for them, and it ended up going to the Supreme Court of Canada, and after a long and messy fight, probably quite expensive, basically the joint ownership as an estate planning tool was, well, not struck down, it was made very difficult to use. So this is something that we probably should not be recommending today in terms of estate planning, but it does have some estate planning implications. So we have two kinds of joint ownership. We have tenancy in common, which is the legal default if you have joint ownership and you haven't further defined it. And simply what happens here is you have two people who each own a portion of some property, and now it's just going to flow to the other party on the death of, sorry, I apologize. It's going to flow to the will of the deceased person, and the other party now is left with a new business partner, a new joint owner, whatever it happens to be, to deal with. Right of survivorship is the one that I think most people still equate with joint ownership, although, as mentioned, tenants in common is the legal default. What happens here with right of survivorship or joint tenancy is that on the death of the first owner, the surviving owner becomes the owner of that deceased party's interest in that joint property. There's no tax benefit to this. Again, this is a misconception that I often run into. Basically, the person who's died would just be deemed to have disposed of and therefore have to pay tax on their portion of the ownership interest. Now, if you have a situation where a rollover would normally exist, like between spouses, then that would still apply here. So it is still possible to use joint ownership, but we have to be very, very clear as to what our intentions are. And in fact, lawyers today will say, if you're going to do this, you want to express this very clearly. Express it in writing. This is my intention. This person is now a joint owner with me, and my goal is that when I die, that person would enjoy the use of that property. So that wraps up our presentation on beneficiary designations. As you can see, there's an awful lot there, many places where we could make beneficiary designations. So it's your responsibility here as the advisor to make sure that you do pay attention to all of these different areas for your client. There should be some regular review here. This is something where you should have some sort of process in place that says, this is when I review my beneficiary designations for my clients. And we do have to recognize then all the different possibilities and all the different possible outcomes here. And not just to get the stuff that you're taking care of, but to make sure that your clients do things like update their beneficiary designations on their group insurance policies. There are numerous places where this can have an impact. And if your client doesn't consider all of them, then we can end up with some uncertainty at the time of death. So I hope that helps. I hope that we have a good, broad understanding along with some fairly narrow detail around what constitutes a valid beneficiary designation, around some of the rules around these beneficiary designations, and some of the hazards that can befall somebody who hasn't properly taken care of their beneficiary designations. Thank you very much, and I hope you enjoy your continued studies.